purpose of my lecture is to outline some historical introduction into the issue of relation between law and politics. This subject is extremely broad, so I will deal only with some of its aspects, focusing on the tasks assigned to lawmakers in selected political and legal doctrines. The review of positions is by no means exhaustive, and to a large extent merely points to some important problems. As early as the 1920s, the prominent German jurist and law philosopher Carl Schmitt stated in his famous essay Political Theology that all significant concepts of modern theory of the state were secularized theological concepts. And he gave an example of the replacement of the omnipotent God by the omnipotent lawgiver. For Schmitt, this was not a purely formal change. It reflected certain ideas about what the state is and what the tasks of a lawgiver are. It is evident that this situation, which Schmitt described, was a consequence of centuries of civilizational transformations concerning mainly political and legal culture. These transformations consisted primarily in undermining the classical concepts of politics and law, and consequently in rejecting cultural heritage, which, according to Polish scholar Felix Koneczny, can be associated with the concept of Latin civilization. Let me make this concept the axis of our considerations now. By civilization, Koneczny meant the method of communal life. This approach to civilization was formed primarily on the basis of orders that are normative in their nature. That was religious order, ethical order, and finally legal order. These orders gave the frame for the development of this communal life and gave it features of some kind of system. In Koneczny's view, the Latin civilization is not the same as the Roman civilization, and of course it's not the same what was the Byzantine civilization. The Latin civilization came into being after the fall of the Roman Empire, forming itself under tender care of the Catholic Church, which became the depository of Roman heritage, giving it, at least partially, a new content. This was especially the case of the perception of law and rejection of the Roman principle of imperial legislation, quod principi placuit legis habet vigorem, which can be regarded as the seed corn of the subsequent approach to the law that was intrinsic to the Byzantine civilization. In the Latin civilization, the law had an a posterioristic nature. It means it was a sum of social experiences. As Koneczny says, it was born out of life and it followed life. Therefore, it was the opposite of the a priori law that Koneczny wrote about, let me quote, the predefined assumption forges the law by deduction, not focusing on real life, bending it by force to the predefined scheme, breaking it and even destroying it. A posteriori law is a law of evolution. A priori law is a law of revolution or stagnation. These considerations can certainly be regarded as accurate, provided they serve to characterize only some institutions of positive law. The views of Koneczny, an enthusiast of Latin civilization, recall the main assumptions of the 19th century historical school of jurisprudence, whose most outstanding representative was Friedrich Karl von Savigny. And this scholar and aristocrat believed that positive law, like language or traditions, evolves in a natural way, at the same time reflections the national spirit. This is what Savigny described as the political element of law. Quite similar views on law are still stated today, especially in some Anglo-Saxon conservative circles, for example, by Roger Scruton. This is not surprising because the common law is a typical a posteriori legal system. But let us return to the concept of the Latin civilization. As I have already noted, the Catholic Church played a fundamental role in its creation. An important issue is a relation between the Latin civilization created in the Middle Ages and its important predecessor, the classical Greek and Roman civilization. Konechny wrote that the relation between Catholicism and classical civilization must be expressed in words. The Church has conquered this civilization. A key concept which developed in the Greco-Roman antiquity and then became the subject of the proliferation of fathers and doctors of church was natural law. Due to time constraints, I will make only some general and basic comments on this subject. Above all, we should pay attention to the view of Aristotle, who believed that man is by nature a social being, and therefore he is designed to live in a community. The beginning of such community is family, which is formed by formed as a result of marriage. With time, families form communities, otherwise known as communes, and then, by uniting them, they form a state, which thus is a natural community. The state is formed to make life possible, and it exists to make life good. And according to Aristotle, virtue of citizens of the state is strictly connected with its political system. If nature inclines man to live in a community, then certain principles of functioning in such community can be derived from nature. Here we get to the concept of natural law. Its meaning can be presented to us by a prominent Roman speaker and politician, Marcus Tullius Cicero. In his Pro-Milone oration, Cicero, on the example of an act of self-defense, explained natural law in the following way. There exist judges this law which is not written but inborn. We have not learned it, received it or read it, but from nature herself we have snatched, imbibed and extorted. A law to which we are not trained but in which we are made, in which we are not instructed but with which we are imbued. The law, namely that whenever our life falls into some ambush, is attacked or is set upon by brigands or enemies, there is every honest reason for saving oneself. Cicero's view had a far-reaching impact on the early Christian writer Lactantius, who adopted the concept of natural law from the pagan speaker. In his most important work, Divinae Institutiones, Lactantius quotes a passage from Cicero's De Republica, which refers precisely to natural law, which Cicero describes as vera lex, and Lactantius as dei lex. Characterizing them, the speaker pointed out that it is consistent with the rational nature of man, unchangeable and eternal. Therefore, positive law cannot in any way modify natural law, whose author and sole interpreter is God. Despite a significant convergence of Cicero and Lactantius' perceptions of natural law, it should be noted that there are also some differences that were not only semantic, since according to the pagan speaker, natural law is linked to the concept of utilitas communis, and thus serves to achieve the common good, whereas the concept of utilitas was the subject of criticism from Lactantius. Even though Cicero sees the pragenesis of natural law in God's establishment, he seeks its rationalization, whereas for Lactantius it is essential that the unchanging and objective moral order, defined by a prominent French scholar Jean Godmet as a higher order, is concluded under the definition of natural law and aimed at the realization of a creator's will. In the Middle Ages, the main theoretician of natural law was Thomas Aquinas. Thomas defined law as an ordinance of reason aimed at the common good established by legal authority and promulgated. However, such an approach to law was governed by a certain hierarchy, with an eternal law at the top containing God's wisdom, which is revealed to man in the form of natural law. As stated by Thomas, this participation of eternal law in the rational creature is called natural law. However, human law, which must correspond to natural law, is located lower in the hierarchy. The aim of natural law, the first and basic precept, is that good is to be done and pursued, and evil is to be avoided. All other precepts of natural law are based upon these first precepts. Therefore, in an epistemological dimension, natural law is subject to rational cognition. In fact, the man's task is greatly facilitated in this respect because they have an innate ability, which Thomas called habitus, to discern right from wrong. Thomas referred to this ability with a Greek term synderesis. In a different part of Summa Theologiae, synderesis is defined as the law of human thought. Hence, as emphasized by the Catholic philosopher and lawyer Francis Suarez, referring to the philosophy of Thomas, synderesis is the same for all people, just as there is only one truth and only one natural law. Thus, natural law can be known to all people, even Gentiles. The primary task of a lawmaker is therefore to create a law which corresponds to natural law. The lawmaker who would introduce laws that are contrary to natural law becomes a tyrant, and his legislation, as unjust, is not binding in human conscience. We can therefore see how the Latin civilization had acquired the ancient concept of natural law by giving it its rightful place prior to positive law. This clearly determined the role of the positive lawmaker as the discoverer of law, not the creator of law. It gave a sense of stability and guaranteed, at last in the theoretical dimension, that the law would not become a justification for crime and would correspond to the moral norms. When we can see a change in the approach to the legislator's role, what was the path from legal a posteriorism to a priorism? It seems that Marsilius of Padua was a pioneer in this respect. Although philosophical foundations for the concepts formulated by Marsilius had been laid earlier by representatives of nominalism. In his work, Defensor Pacis, Defender of Peace, Marsilius emphasized that the governance with the consent of the people determines whatever a given system is good. The people are also lawmakers, and as Marsilius said, it is the people who have the will expressed in speech in a general assembly of the citizens. It commands or determines, subject to temporal penalty or punishment, that something should be done or omitted in respect of human civil acts. Marsilius knew that the concept of law also included a role containing precepts relating to the conduct of man, commanded for reward or punishment in the future world. But he did not consider such rule as a law in a strict or proper sense. He did not mention natural law at all, even though he referred to the concept of common good from Aquinas' philosophy. It was, however, understood in a relativized way, as Marsilius wrote, what all citizens strive for, both intellectually and emotionally, is presented to us in a more convincing manner as truth, and is treated by us more decisively as something positive. So there is no objective truth and no objective common good in this philosophy. The views of Marsilius of Padua left their mark on the later thinkers. The ones worth particular mention are Thomas Hobbes, who adopted Marsilius' concept of the state as the defender of peace, a guardian of order acting in the interest of individuals, and Jean-Jacques Rousseau, who became a theoretician of popular sovereignty, the foundation of which can be found in Marsilius' work. And let us first focus on the concepts coined by Hobbes, contained in his most prominent work entitled Leviathan. Even though Hobbes adopted the vision of the state as a defender of peace from Marsilius of Padua, he considerably expanded the argumentation that was supposed to justify this vision. In his work, Hobbes outlines his own pessimistic vision of human nature. Bellum omnium contra omnes, aware of every man against every man, was supposed to be the original state of human existence. This assumption determines the content that Hobbes attributes to both the natural law and the natural light, and in Latin is lex naturalis and jus naturale. According to Hobbes, the fundamental right of nature, the primary precepts, we can say, was the liberty to do everything that each man in his own judgment and understanding would consider the most appropriate for the preservation of his own being, his own life. The substantive law of nature, at least from the formal point of view, was still understood in the classical sense, constituting an immutable and eternal law discovered by reason. However, this content, which corresponds to the natural right, changes. Hobbes wrote, "A law of nature is a command or general rule discovered by reason, which forbids a man to do anything that is destructive of his life, or takes away his means of preserving his life, and forbids him to omit anything by which he thinks his life can be best preserved." As we may remember, Thomas Aquinas wrote that natural law directs man to the good. Hobbes' philosophy is solely about owns one good. And one may lie down their natural rights for the sake of one own good only, as may be required by the community. The natural character of the right of self-defense, and therefore the right to take actions aimed at preserving one's own life, can be noticed already in Cicero's work. However, this was only one of the human rights that result from the natural law. Hobbes made it a fundamental right, determining the content of all other rights. The aim of the natural law and the aim of each man is therefore self-preservation, which should be understood as the preservation of man's own existence, which is devoid of eschatological perspective. Hobbes' concept of natural law determined the fundamental goal of the state, which, as we have said, reproduced the earlier thought of Marsilius of Padua. It also reflects the genesis of the state formation. As pointed out by Hobbes, the state is one person of whose acts a great multitude of people have made themselves the authors, doing this by mutual covenants with one another, so that the commonwealth may use the strength and means of them all as he shall think appropriate for their peace and common defense. He who carries this person is called sovereign, and he performs his function either through violence, or the possibility to apply violence, or through the voluntary surrender of the individuals to his government. Hobbes' anthropological pessimism and fear of annihilation, probably shamed by his own experience, led him to the justification of the despotic power, which he called sovereign power. As Hobbes pointed out, if the majority had established the sovereign, then any act against his authority is an act of injustice and therefore is lawlessness. The assumption that power is delegated to the sovereign as a result of social settlement and decision adopted by the majority led Hobbes to conclude that the position of sovereign cannot be abused. Every individual man is an author of everything that sovereign do. So someone who complains of being wrong by his sovereign complains about something of which he himself is an author. So he oughtn't to accuse anyone but himself, writes Hobbes in Leviathan. Such a sovereign has only one obligation. The sovereign has everlasting authority over all things, except that he is bound to observe the laws of nature. For he himself is the subject of God. We can read in Leviathan. The first natural right, however, is the right to self-preservation of one's own existence. But sovereign, as Hobbes said, can successfully and legitimately condemn his subject to death. Thus the monstrous Leviathan begins to devour those who have shaped his existence. Indeed, the aim of Hobbes' Leviathan, a metaphor for the state, is not to preserve a man, but to preserve his own existence, the state existence. Schmidt was therefore right when he writes that Hobbes' interpretation of Leviathan as a great person is a methodological and systematic necessity resulting from his concept of natural law. Rousseau, on the other hand, was anthropological optimist. Despite such a different view on the starting point of the humanity, he came to conclusions similar to those of Hobbes. The basic and primary right is the right to protect one's own life. As Rousseau further pointed out, the purpose of social contract is to find a golden mean between individual's liberty and the need to ensure his safety. Hence, Rousseau captured the essence of social contract in the following way. Each of us puts his person and all his power in common under the supreme direction of the general will, and in our corporate capacity we receive each member as an indivisible part of the whole. The literature concerning this subject suggests that social contract emphasizes the principle of popular sovereignty. This sovereign power was inalienable and indivisible, but also, as Rousseau wrote, need give no guarantee to its subjects, because it is impossible for the body to wish to hurt all its members. Sovereign merely by virtue of what it is always what it should be. As can be concluded, the general will cannot go wrong. But Rousseau nevertheless admitted that in practice the sovereign people did not really know what was good for them, which he justified by factional battles and insufficient civic education. What are the limits of sovereign power? Rousseau wrote that the social contract gives the body politic absolute power over all its members. Contrary to its name, there are limits of this power. The sovereign has no right to burden one subject more than another, wrote Rousseau. With such an opinion, we come to a position in which the criterion for assessing the limits of superior power is of formal nature, while a norm is of general and abstract nature. It may be an expression of general will. Unlike Hobbes, Rousseau does not provide any deeper reflection on natural law. The only lawmaker is the people who embody the general will. The objectives to be attained by the sovereign people and therefore determined by an anthropological assumption adopted in Rousseau's work are based on the fiction of social contract. The lawmaker is liberated from the shackles of natural law. Both Hobbes and Rousseau were philosophers of a period of an intellectual ferment that heralded the revolution in the case of Rousseau, or acted during revolution in the case of Hobbes. It is therefore not surprising that their views constitute philosophical foundation for the concept of a priori law, which Koneczny describes as revolutionary and unfamiliar to Latin civilization. Hobbes' philosophy is more interesting in this respect, as it reveals the consequence of such state of affairs of that situation. Eric Wegelin, whom I will quote in extenso, put it aptly: the revolution of movement is successful, if successful, never result in a realm of sweetnesses and light without compulsion, but always is aggravated forms of centralized dictatorial power. The greatest instances of this sequence are the dictatorship of Cromwell in the wake of the Revolution of the Saints, the dictatorship of Robespierre and Napoleon in the wake of exuberant freedom in the French Revolution, the dictatorship of Lenin and Stalin in the wake of a communist revolution. The reason for the inevitability of this sequence, for the appearance of the Leviathan that will keep down the proud, have been analyzed profoundly by Hobbes. That's the end of the quotation from Eric Wegelin. Do these concepts have any significance for assessing the contemporary condition of state and law? It appears so. A priori law, unfamiliar to Latin civilization, that constitutes our historical heritage, dominates modern Europe. Lawmakers, succumbing to pressure from groups that are not necessarily numerous but very influential, seek to deconstruct the natural social order and create a new man. Today, the revolution does not have the face of a specific person. It does not have a specific name, Cromwell or Robespierre, but it still possesses a free to authentic freedom of man, forming, to use the well-known term of Professor Roberto de Mattei, the dictatorship of relativism, much more subtle and thus much more dangerous. Thank you very much for your attention.